5 seconds to go. Start. This appeal by special leave challenges a judgment of the Kerala High Court which allowed an appeal preferred by the respondent, hereafter called Popular Estates, and held that an area of slightly over 402 acres, that is 100 hectares, and 155.90 acres vested in the state of Kerala, hereafter the state, and the rest of the land of a total 1534.40 acres had to be treated as plantation and thus belonged to the said respondent. Popular Estates became owners of 1534.40 acres of land. Those lands were acquired by sale. Messrs. Popular Automobiles, a registered firm, through 4 registered deeds executed in 1963. These lands fell to Popular Estates' share upon partition of the firm's assets. The Kerala Private Forests Vesting and Assignment Act 1971, hereafter the Vesting Act, came into force with effect from 10th May 1971. Under Section 3 of the Vesting Act, all private forests vested in the state government. The act was challenged before the Kerala High Court, which struck it down by a judgment in 1972. That judgment was reversed by this court's ruling in 1973. The forest authorities attempted to take possession of large areas of land occupied by Popular Estates, arguing that they were private forests and had vested in the state under the act. Popular Estates moved 2 original applications before the Forest Tribunal hereafter under Section 8 of the Act, claiming a declaration that no part of the estate consisting 1534.40 acres was liable to vest in the state, since it was being cultivated, and hence it was exempt under the provisions of the Vesting Act. The state opposed those applications. The tribunal appointed a commissioner to inspect the entire area and report about its state to it. The commissioner, after a preliminary inspection, was of the view that a detailed survey of the land was necessary, as most of the land was situated on hills and therefore inaccessible. Private surveyors appointed to survey the land were unable to complete the work. The tribunal directed Forest Department survey officers to survey the lands. The tribunal thereafter dismissed the original applications. It made critical comments about the manner in which the surveyors had made the report and recorded that this exclusion by the forest officials may be due to the fact that the magic money lulled them to sleep over the rights of the government, or may be due to the fact that the claim originally put forward by the forest officials was false. Neither way, it is not very complimentary to the respondents here or to those officials concerned. It is for the government to make necessary immediate inquiry in this matter through some official other than forest department official, if the government so think, and ascertain whether any area which legitimately come under the classification of private forest and which had vested in the government besides bits 1 to 7 have been excluded by the forest officials or by the forest survey officials. On the basis of the Commissioner's report and the facts mentioned by him, I am inclined to think that prima facie it appears that areas which should really be vested forest have been excluded when the claim was confined to 100 hectares. Stop.